This is our third webinar in a series of COVID conversations for Wayne County. We have a lot of people either on the line today through Zoom or our YouTube feature. So we've had a great turnout. This is a very valuable subject that we're talking about today. So once again, welcome everybody. This is a webinar series in collaboration with Wayne Economic Development Council, Worcester Area Chamber of Commerce, and Orville Chamber of Commerce. And we have Justin Starlin participating, as well as Lori Reinbold. And throughout the webinar, you'll either hear from them or me regarding questions. So with that, Bob's going to talk a little bit today about the employment law as it relates to FMLA and just workplace practice. So with that, today's questions, if you have a question, if you are looking at us or if you're viewing from the Zoom feature, there's a chat button that you can type your questions out, and myself, Justin, or Lori would be happy to relay that on to or for you. Or there's actually a raise your hand function. So if you have more of a technical question that you would like to ask yourself, please just hit that feature and we will see it, and then we will bring you on live so you can ask the question directly to Bob. So, and if you're watching on YouTube, you can either email a question, if you have one, to myself, Justin, or Lori, and then we will pop on and read that for you as well. So we want this to be very interactive. This is for you. In this series, we're trying to bring valuable information that's that you can take back to your workplace and use it as you go forward as we get through these trying times. So once again, I'm going to kick this off to Bob. Justin, did I forget anything?
Yeah, the only other note, Tom, is that you did cover the question, but we may not be able to get through everybody's question in the time allotted. So make sure that if you do have a question, please put it in the chat or send myself an email, Tom an email, or Lori an email. And we'll make sure that your question gets answered today.
Okay, and hopefully everybody can hear me okay. We've had issues in the past. A lot of times it's on your end and you just need to turn the volume up on your computer. So sometimes that gets confusing for people. So with that, I'm going to turn this over to Bob. Bob, thank you so much for joining us today.
Tom, thank you. And thanks, Justin and Lori. Happy to be here. There's a lot going on, as you all know, in the law. Things are changing really by the day or by the hour. And our goal today is to bring you up to speed. It's to some level of depth on the Families First Coronavirus Response Act with respect to the paid sick leave and expanded FMLA provisions of that act. That's going to be the deep dive we're going to have today. And we will also talk about or answer any questions relating to other workplace issues relating to the pandemic. And I guess I'll start second and just spend a couple minutes talking about the other workplace issues before we dive in deep on the FFCRA. The biggest news, of course, is the state of Ohio shutdown order, which was extended yesterday by Dr. Acton acting through the governor's recommendations. Covers a lot of our businesses, and the order itself does not have a lot different from the original order. It does have some additional restrictions, but that's really kind of around the edges. The tone for people who are watching the governor's press conferences on a daily basis seems to be they're getting more serious about enforcement. We noticed that just yesterday a lawsuit was filed in Stark County by the City of Canton law director against a vape shop that's staying open over there. And I will say, as a person who's scoured every line of that now 13-page order, the lawyer looking at the order can find a lot of gray and ambiguities. We're telling our clients, if you're allowed to be open under the order, you can be open under the order. But our contact with health departments through Northeast Ohio generally is the spirit of the order is what they tend to enforce rather than necessarily the letter of the order. And the spirit is they want people to stay at home if they can stay at home. The other thing I would say is at the outset, one question that we're getting a lot, and I think we'll get a lot more of, is what happens as the number of cases continues to increase. What happens if we have a person who's symptomatic or who has COVID-19 in our workplace? And the Centers for Disease Control has pretty much laid a roadmap of guidelines for that. They do change from time to time as the data improves and as the science develops. But the primary advice, if someone comes to work or with COVID-19 related symptoms, which are fever, cough, shortness of breath, they sometimes include chills in the list of symptoms. They should be isolated. They should be sent home right away. And persons who were in close contact with that person, not only that day, but in the 48 hours preceding the development of that person's symptoms, should be advised that they were in close contact. The ill employee should not be named. There are still some privacy concerns relating to that, but they should be advised that it's our understanding you have been in close contact with someone who has symptoms of COVID-19, or if it's the case, who has tested positive for COVID-19. And the guidelines that the CDC recommends are those persons that are in close contact be sent home and advised to self-quarantine for 14 days, monitoring their symptoms and letting people know if there's an issue that comes up with any health concerns, to let their doctors know. So with that in mind, what is close contact? The CDC tells us that also, and that is being within 6 feet of a person for an extended period of time. They define extended period of time. They say, some people say 10 minutes or more, some people say 30 minutes or more. So they say somewhere in that range, but even less if it's clear that there's been sneezing, coughing, something like that within that close contact period. So the idea really is to err on the side of caution there, and that's our advice to clients as well. So that's a little bit of background there, and now we kind of want to take a dive into the Families First Coronavirus Response Act. And as Tom had said, we encourage any interaction questions people have along the way. I'm going to take a quick break and get my technical guy. I'm not sure that my notices, Joseph, are getting hidden here. Got my son home from New York City, so he's self-quarantining, and so am I actually for 14 days. I had a notice come up over here. I don't know if that is hidden or not.
No, it's not broadcasting to your screen.
Okay.
Here. It's only broadcasting this screen and your video.
Okay. So we're self-quarantining. We're about 13 days into the 14, and all are healthy, so that's good. Lawyers always start their presentations by saying this should not be taken as specific legal advice. As I said before, the law and the regulations and the guidelines are changing literally every day. So we advise you to continually monitor. If you do have questions, get in touch with your legal counsel, because some of this stuff is very technical, as you'll see, in terms of what you need to do in terms of deciding whether to grant paid sick leave or the expanded family medical leave. Because if you grant it, and you shouldn't grant it, good for the employee, but you cannot take the tax credit and recover that money from the IRS or from the government. So let's talk about the act. The act was effective on Wednesday, expires at the end of the year, so it's a temporary measure. It covers all private employers in the United States with fewer than 500 employees. And when you're counting heads, a part-time employee counts as much as a full-time employee. Also covers most public employers. When counting employees, you count employees on leave, you count temporary employees, you don't count independent contractors. And there is a kind of carve out, leave can be denied to certain healthcare workers and first responders. But the regulations say that employers of those healthcare workers and first responders should act judiciously in denying leave. It's got to be a balance between having enough people out there to help people, but also not spreading the virus. So we'll talk first about the paid sick leave provisions. There are 6 reasons that qualify for paid sick leave. And sneak preview, there's only one of these that qualifies for the expanded family medical leave. There is some confusion out there about that. Paid sick leave, you're eligible for that if you're unable to work or telework because you, the employee, are subject to a federal, state, or local quarantine or like isolation order relating to COVID-19, or you've been advised by a healthcare provider to self-quarantine for a COVID-19 reason, or if you're experiencing COVID-19 symptoms and are seeking a medical diagnosis. That's the first three reasons, all relating to you, yourself, your condition. The other reasons, the employee might be caring for an individual described in the first two, a person who is self-quarantining or has been advised by a medical provider to self-quarantine or is under an order, an isolation or quarantine order. Or employee is caring for his or her child under circumstances where their school or their place of care is closed or their child care provider is unavailable. The second part of that is if they don't go to a formal child care, but they might have a neighbor or someone else that takes care of their child. That also is a qualifying reason. And if you're going to take advantage of that fifth provision, the employee also has to certify that no other suitable person is available to care for the child during the time of leave. And we'll talk a little bit later about the certification and documentation process. The final reason is kind of a catch-all. It's not very important right now. Experiencing a similar condition specified by the Secretary of Health and Human Services. I would call that the in case we forgot anything provision. The Secretary of HHS can add something later, but we don't expect that to happen. And we would note that this leave is available from the first day of employment for the paid sick leave. Now, the second type of leave under the new act is the expanded FMLA. And again, there's only a single qualifying reason to get the expanded FMLA, and that is caring for your son or daughter under circumstances where due to COVID-19 related reasons, the school or place of care is closed or the provider is unavailable, and if no other suitable person is available to take care of the child during that period. And you need to be employed for at least 30 days prior to the leave request to get that. If you've recently been laid off, you're eligible for this leave on day one if you worked or if you were on the company's payroll for 30 of the 60 days immediately prior to your layoff. Now, we talked about the qualifying reasons. What are not qualifying reasons? This is the big one. If your business has shut down, whether it's due to the stay-at-home order or due to basically lack of work, lack of business due to what's going on, that does not qualify your employees for paid sick leave or expanded FMLA. Or if your employee lays you off for any reason at all, whether it's a stay-at-home order, lack of work, or anything else, or if the employer reduces your scheduled work hours due to the decline in business or for any other reason. The remedy for the employee in a case like that is not paid sick leave, is not expanded family medical leave, it's unemployment. And as many of you know, the unemployment benefits have been enhanced significantly by the state and federal government, including waiver of any waiting period and a significant boost in the weekly unemployment benefit on a temporary basis from the federal government. What happens if an employee is on paid sick leave or EFMLA for a few days and then the business shuts down? Well, the spigot stops for the paid sick leave or the EFMLA at the time of shutdown. You pay it until the time of shutdown, but after that, there's no further obligation unless and until you start back up again. And the employee's remedy again in cases like that is to pursue unemployment. So how much leave is provided? Under paid sick leave, an employee gets up to 2 weeks. It has to be done during this year. It can't be carried over. The law expires on December 31st, 2020. For a full-time employee, that's 80 hours. It doesn't matter if an employee averages 50 hours a week, that doesn't give them 100 hours. The paid sick leave is capped at 80 hours. For a part-time employee, it's their hourly equivalent of 2 weeks work. It's easy if people have a regular part-time schedule to figure out what that is. If there's no normal part-time schedule, you look back 6 months and take the average amount they work per week. And if it's less than 6 months, you use the hours either agreed at the time of hiring, or if there's no such agreement, you just look back and what are their average hours worked over their term of employment. And that is what you base the 2 weeks on. If they average 17 hours a week, they get 34 hours of paid sick leave, for example. And how much do you pay under paid sick leave? Well, it depends on the reason for the paid sick leave. If it's one of those first 3 reasons we talked about, it's paid at 100% of the regular rate of pay, with a cap of $511 per day for highly compensated employees. Those 3 reasons are things that directly affect the employee or the employee's health. The employee is subject to a quarantine or isolation order. The employee's been advised by a healthcare provider to self-quarantine, or is experiencing COVID-19 symptoms and is seeking a medical diagnosis. For those reasons, the employee is entitled to be paid at 100% of the regular rate of pay for 2 weeks. Now, if it's for any of the other 3 reasons, it's a lower amount that is paid, 2/3 of the regular rate of pay, which is capped at $200 per day. And that is for an employee who is caring for an individual who's subject to a quarantine or isolation order, or who has been advised by their healthcare provider to stay at home, or if an employee is caring for their child due to their school or normal child care situation being unavailable. In those cases, it's 2/3 of the regular rate, capped at $200 a day. Had a few clients ask, what if we want to pay the full rate, or what if we want to pay in excess of the cap? Nothing prevents you from doing that, but the reimbursement you get from the federal government is capped at these numbers. And so anything over and above that would not be reimbursable by the federal government. That would be your nickel. And then in terms of how much leave you get under the expanded FMLA, we talked about you get 2 weeks under the paid sick leave. Under the expanded FMLA, you get up to 12 weeks. The first 2 weeks of that are unpaid. I think primarily with the idea that in many cases, the employee will take those first 2 weeks and use their paid sick leave, and then this would fill in after that. But again, remember, there's only a single qualifying reason for the expanded FMLA, and that is when the employee is caring for their child under the circumstances we've discussed previously. So if an employee is subject to a quarantine or isolation order, advised to stay home, is taking care of someone under those conditions, they get the 2 weeks of paid sick leave, but they do not get the expanded FMLA. And if you choose to pay them beyond that, again, you can do that, but that is not a benefit that the government will pay for ultimately. And I guess we talked in the previous slide a little bit about this for expanded FMLA. No pay required the first 2 weeks, and 2/3 the regular rate for up to 10 additional weeks. So for a person who happens to miss 12 weeks to care for a child under the circumstances we described, there could be up to a $12,000 benefit for that. $2,000 for the first 2 weeks under the sick pay, and then $10,000 after that under the expanded FMLA. We've used the term regular rate of pay a number of times. That's what this is based on. And that's not what you're receiving at your last paycheck. They look at the average of your regular rate in the 6 months prior to taking leave, and that's what the regular rate of pay is considered to be. If an employee has not worked 6 months on the job, you take the average for each week that they've worked for the current employer. And you do include commissions and tips, and in all cases, it must be at least the minimum wage, which is $8.70 an hour in Ohio. And the words the regulations use is the applicable minimum wage. There's been a little bit of disagreement among people who are analyzing this so far as to whether a person who, say, a food service worker who relies upon tips, if that $8.70 must be provided. It's unclear from the regulations, but I think the safest thing to do is be sure to provide them with that minimum amount, and you'd be able to claim that back from the government. There's been a fair amount of talk about a small business exemption, and a lot of employers are very interested in this because they're concerned about the impact of these expenses on their operations. One of the things I want to emphasize is this is written as a very, very narrow exemption, and we'll talk about that the statute says businesses with fewer than 50 employees can claim the exemption if providing the payment will, quote, jeopardize the viability of the business as a going concern. And that's a pretty high standard. It's also important to note that this exemption only applies to one of the 6 qualifying reasons. That's the reason needing to stay home to take care of your kids whose school or childcare is unavailable. Any of the other 5 qualifying events, you know, the quarantine or isolation orders, the medical, staying home for medical recommendations, those things, being sick, no exemption, no small business exemption. The pay must be paid for those reasons. Now, to elect this exemption, the employer must document that it has made a determination and retain that documentation in the file. And this is what the employer must determine, one of these 3 things. A quote unquote authorized officer of the company must determine that providing the leave will result in expenses exceeding revenues and will cause the business to cease operating at a minimal capacity, or the absence of the employee or employees requesting leave would substantially risk the financial health or operational capabilities of the company because of the skills, knowledge, and responsibilities of those employees, or there aren't sufficient workers available to perform the labor or services needed for the small business to operate at a minimal capacity. So they're pretty high standards that you have to reach. If a finding like that can be made, it needs to be explicitly found and documented. So I would just caution people to be very judicious about using that exception or that exemption. We've had a number of questions on whether the leave that we're talking about in this presentation can be provided intermittently. And for those who are not already familiar with the Family Medical Leave Act, the intermittent leave essentially means piecemeal leave taken every other day, maybe a few hours a day. The question is, do we have to or should we provide the leave, the paid sick leave, or the expanded family medical leave intermittently? Well, the regulations have said the employers don't have to do that, but they are encouraged to do that. And they're encouraged to be flexible with a couple of guidelines. If the employee is actually working at work, the employer may permit the intermittent leave, but only for the type of leave that's necessary to take care of kids who are not sick, but are home from school daycare. Reason being, they don't want to let you come into the work site if you are taking care of someone who is subject to a doctor's advice to stay home, quarantine or isolation order, or if you yourself are sick or in one of those categories. But if you're merely taking care of non-sick kids, you can come to the work site, or you can make an agreement with your employee to have them come to the work site and work every other day, work half days, work whatever way you would like to see them work. And then you'd have to keep track of the hours that they're actually working and the hours that they're taking the leave for documentation purposes. If an employee is working at home, teleworking, the employer may permit intermittent leave for any reason, because there's not the contagion issue that there would be if they were in the workplace. And again, the regulations recommend employers and employees to collaborate and be flexible in trying to find a way to make intermittent leave work. So we've talked about what you have to pay out. How do you get it back? It's a little bit precise here, and I think Tom's going to send this presentation out to people who have registered for this, but we would suggest you really follow these chapter and verse, because it is technical, and you're asking for money back from the government or claiming money back, and you want to be sure you have you jump through all the hoops precisely. Business is entitled to get 100% reimbursement for the paid leave. That includes health insurance costs, both the employer and the employee share, and self-employed will receive an equivalent credit. And I will say they're trying to make the process as seamless as possible, because an employer can immediately withhold from amounts that are typically paid to the IRS on a payroll by payroll period the amounts that they've paid out for these leaves. So federal income tax, the employers and employees share of FICA, you could hold back amounts that you pay for leave. And if that doesn't make you whole, if that doesn't reimburse you 100%, you can apply for an expedited refund of the balance with a new IRS form that was developed and published just this week, Form 7200. So let's put some numbers to that to try to make it a little clearer. An example: suppose you have a payroll of $25,000, and out of that, your payroll tax obligation would be $7,500 for tax withholdings and for FICA, which is Social Security and Medicare, through the company. And let's say in that payroll, you had to pay $1,000 in sick pay wages and $500 in insurance premiums for a person receiving sick pay. So what that means is, when it's time to turn around and remit your withholdings to the IRS, rather than remitting the full $7,500, you can remit $6,000, and you can hold back the rest. So you're really not out of pocket for the sick pay wages and insurance. You're made whole right at the beginning there. Now let's pretend the facts are a little bit different, and instead of $1,000 in sick pay wages, you have $8,000 in sick pay and insurance premiums. So in that case, the $7,500 that you would remit would not be sufficient. So you wouldn't have to remit any, and then you'd file for a refund of the additional $500 through this new IRS Form 7200. Excuse me. Now, documentation and notice, bear with me because it's a little technical, but it's very important, I think. In terms of notice, because of the nature of the virus, the regulations say advance notice is not required. Notice is required as soon as practicable. Notice provided by a family member is going to be generally okay, as well as oral notice. But ultimately, you have to get required documentation. And I will say, I've read the regulations. They came out Wednesday night. It's a little bit ambiguous on the form of the documentation, because some of it calls for oral or written. The prelude to the regulations call for a signed statement from the employee, but the regulations themselves don't use the term signed statement. Better to get signed statement. If you can't, you need to keep track of all this in your own writing and in your own files. But the documentation includes the reason, one of those 6 reasons we've talked about several times, the reason for requesting the leave, and an actual statement the employee is unable to work, including telework for that reason. The dates for which the leave is requested, which obviously can be a moving target depending upon how circumstances develop. Then there needs to be documentation of the reason for the leave. And that includes the name of the entity issuing the quarantine or isolation order if it's due to a quarantine or isolation order, the name of the healthcare provider advising self-quarantine. Now notice it asks for the name. It does not require a written statement from the healthcare provider. And I think that's being sensitive to the busyness of healthcare providers right now. But the employer is or the employee is required to provide the name of the healthcare provider. And then if leave is requested to take care of the child, the employee is required to provide you the name and age of the child or children, the name of the school or the daycare provider that is unavailable, and they need to represent that no other person will be providing care for the child during the period that the leave is requested. So if you have if you have father and mother working at your workplace, both of them can't take this leave at the same time. There needs to be representation. No other person will be providing care. Now, the regulations also say you're required to have, quote unquote, additional material as needed to support a request for tax credits pursuant to the FFCRA. That's kind of gobbledygook, but could be very important because the regulations then provide a link to an IRS frequently asked questions document. And sneaking into that document is a further requirement that says if the sole reason to stay home is to take care of a child who is over the age of 14, the IRS would like a documentation, a statement from the parent that special circumstances exist that require you to be home to take care of that child. And again, that applies if the child is over the age of 14 and if the time off is during daytime hours. So I'm going to guess 90% of employers may miss that because it's not even spelled out in the regulations other than this kind of elusive additional material hint here with a link. But our advice would be for documentation purposes, you're supposed to get the name and age of the child or children. And if the only people that they're taking care of are 15 years or older, you should get a statement that special circumstances require the employee to be home with them. I wouldn't drill down and ask what the special circumstances are, but I'd want them to tell you that special circumstances exist. So the employer must also keep records that show your work, show your math, determining the amount of qualified sick and family leave wages that are paid, and showing how it was calculated. Because again, you're getting money back from the government for this, and you're going to need to show the facts supporting how you're claiming the amount. And the IRS recommends these records be kept for 4 years after the tax is due. That's a typical IRS record keeping requirement. Reinstatement. Generally, this leave calls for when an employee is done with his or her paid sick leave or expanded family medical leave, they have the right to be reinstated to their job or to a job with equivalent pay and benefits. There are some exceptions. If you can show that if the employee would have been laid off, even if he or she were still working, they're not protected from that. They would not be able to be reinstated into a job that doesn't exist anymore. And then for smaller employers, 25 or fewer employees, there are kind of modified reinstatement rights. There's a little more of a break given if you had to replace an employee, had to hire someone else in their stead. You have lesser responsibility to reinstate a person, but you do have the responsibility to try to reinstate them, try to find alternate work in the workplace for them, or even to call them back if there's an opening in the future within the following year, which this person would be suited for. So there still are reinstatement rights, but there's a little more flexibility for smaller employers. What happens if you don't comply? Well, the hammer kind of is 2 times. You can be pursued by an individual in most cases, or by the Department of Labor for up to damages of up to 2 times the actual damages, the amount unpaid, plus attorney fees. You can also be subject to other enforcement action by the Department of Labor. And if you're not in compliance, they're going to come in and look at everything you got, from I-9s to all your other record keeping. So there is an audit risk. It's just best to try your best to stay in compliance here. Now, the Department of Labor has said they'll have a brief non-enforcement period the next couple of weeks, where they won't assess any penalties if they're made aware of violations, as long as the business takes care of the problem right away as soon as practicable. The violations were not willful or not intentional, and they get a written agreement from the business that they will comply in the future. So they give a little bit of time to gear up on this, but the advice is the law is in effect, and people should be complying right away. There are requirements to provide a poster. It's a free poster, can be downloaded from the Department of Labor website. Like all wage and hour posters, it must be posted in a conspicuous place. And because there are a lot of people who are working from home now, if you have teleworkers, you should get that poster to them either via email, direct mail, or you can post it on a company intranet site that the employees regularly utilize. You do not need to go back and provide a poster for individuals laid off prior to April 1st, but anybody you have on hand on April 1st or later is entitled to the poster. And we're advising people generally, you probably have your bulletin board somewhere with all the other wage and hour posters. That's a good place to do the posting. So as I said, that's rather a deep dive into the details of the Families First Coronavirus Response Act, and just touching on a few other subjects too. But I am happy to take any questions that anybody has.
Okay. Once again, Bob, thank you so much. That was great information. We have a few questions coming into the chat line and also on our question line as well. So we're going to we'll try to read a few of these. But if you could just clarify, you talked about the age limit on a child as far as to care for a child. I think it's 15. I thought you might have said 14 at one point. Could you clarify that? Okay,
it's over the age of 14 is how the regulations talk about it. So if you're caring for a child over the age of 14, then you from a documentation standpoint, you should have the employee represent that their special circumstances exist, and again, in daylight hours. It's kind of a strange distinction, but they do make that distinction. So that's a special rule for people if their only child is over the age of 14.
Okay, gotcha. And let's stay on the age question. We had one that said, what if the employee is youth, 16 years old, working for you? Do they get full pay for the part-time during this time, or this is a non-student, or is this a non-student work permit?
If you have a 16-year-old student who qualifies for under one of the qualifying reasons, they would receive the same pay as any other employee would under the circumstances. Be 100% if it's for one of those first 3 reasons, or 2/3 if it's in one of the latter 2 reasons. There's no distinction there between employee or between a minor and an adult in the regulations.
Okay.
Bob, I've got a question here. We had one come in that said that I'm a manufacturer or a distributor. Many of our customers are deemed essential. Does that pass along, and does that mean that we are considered essential as well?
That's a great question. It's and I'd say there may be a legal answer and a practical answer for that. We've looked at this very closely in the stay-at-home order of Dr. Acton. And there is a line that says if you are producing products or services for other essential businesses and operations, you're permitted to stay open. But a very important qualification to that, these the stay-at-home order is being enforced by each county Department of Health, and most counties have said that they will observe the spirit of that law as opposed to the letter of that law. And they're going to look at whether you are providing an essential product or service. So if you are providing an essential product or service to an essential business or to their other businesses that are specifically set out, ranging from technology to biotechnology, pharmaceutical, and so forth. If you're providing an essential product or service, I think a fair reading of the law is you stay open. If you're providing a non-essential product or service to, even if it's to an essential business, my reading of the order is you should be allowed to do that. But I think it's a lot of the health departments are viewing that as, hey, let's observe the spirit. This is a stay-at-home order, and if what you're providing is not an essential product or service, we're going to ask you to stay shut.
And just to follow up on that, maybe a suggestion, Bob. I know that the Wayne County Health Department Commissioner did request that if you have questions, if you're essential or non-essential, to submit a letter to them saying why you feel as if you are essential. So that may be something maybe prudent you would want to look at. That's on their website as well, and we can upload that document.
Okay. Yeah, and the governor and Lieutenant Governor Houston in particular said, apply common sense in determining it. And I think that some cases are very clear. I'm an essential business, or I'm doing, DOD related work, or some work that's clearly essential for an essential business. When the call is closer, I call to them or correspondence to the health department, contacting counsel, something like that would be advised. I don't think anybody really wants to have the health department come out and ask you to shut down. And what I will say is this: the primary source of complaints that generate health department checking things out is employees of the business. And an employee might think, I don't know why we're working. I don't think this is essential. And they may call the health department. Last thing I'll say about that is if you find out an employee has done that, can't do anything about this. That would be impermissible to do any act of retaliation against an employee in that circumstance.
Okay, Bob. This is a question regarding high risk. Can an employee receive unemployment if they are high risk? And if so, do they need a doctor's note certifying that they are high risk and should not be at work?
Well, an employee can receive unemployment if they are laid off for reasons due to COVID-19. And so I think the analysis would be, if they have a doctor's note that advises them to stay home, their first analysis is, with the employer would have, is, can they telework? Are they able to work from home? If the answer to that is no, then the employee could be laid off, and under those circumstances, the employee would be entitled to apply for unemployment. So that's kind of the way I think that the question first becomes, is there an opportunity for the employee to telework under the circumstances?
Okay. And then on the flip end of that, from the employer's perspective, is an employer allowed to involuntarily lay off an employee because they are high risk? Maybe they're 65 or older, pregnant, or just fit one of those high risk categories?
The EEOC has addressed that, Equal Employment Opportunity Commission, and said, no, you cannot, in kind of a paternalistic way, decide this person, I know by the terms of the what the CDC says or departments of health say is in a high risk category, so we're going to lay this person off. That is considered to be, if it's an older person, that would be considered age discrimination. If it's a pregnant person, that would be a violation of the Federal Pregnancy Discrimination Act. So I think it's certainly fine to voluntarily lay a person like that off, but a person says they want to work and they're involuntarily laid off, the EEOC would tell you that that would be impermissible, and if they were to file an action based upon that, you'd be at risk for being found to have been discriminatory. Now, as a practical matter, how many people are going to pursue a claim like that? I don't know, because if you lay them off, they're going to be able to get unemployment. With the enhanced unemployment, many people will be as well off from a wage standpoint, or maybe better off than they currently are. There are some health benefits, concerns that are not necessarily guaranteed with unemployment. But the strict answer to that would be an impermissible decision to lay them off because they're in a vulnerable class.
And Bob, you just hit on it, but we had two questions come in about additional $600 per week that's coming from the federal government on the unemployment claims. Is that active as you know it, and is it available in the state of Ohio?
Yes and yes. The legislation was written in such a way that said each state would have to enter into an agreement with the federal government in order to have that money available, an agreement to comply with certain other unemployment rules. Ohio immediately entered into such an agreement. So that is available to unemployed workers in the state of Ohio. It is active, but everybody will tell you that the unemployment office is just being completely overrun right now. We've all seen what the numbers are. So it may be very difficult to actually get in and to file, even though it can be done online. But the governor has said many times that filing, when you're finally able to get in, it will be retroactive until the day that you're laid off. So that benefit should be available, and the enhanced benefit should be available from the date the CARES Act was signed, which I think was a week ago today.
Justin, do you have a question?
Yeah, I did. There was one saying here that there was one of their staffers was at home taking care of an elderly above 65, their family member. Would that be considered, or would they be eligible for any kind of paid leave?
They'd be available only if they were if they were taking care of a person who was advised by a healthcare provider to self-quarantine. If the person is, I don't want to say merely, but if the person is merely in a vulnerable category, such as being older, but not specifically advised to self-quarantine, then the paid sick leave provisions would not be applicable. I don't think anybody would complain if the employee came to the employer and the employer laid the person off for those reasons. I think that the employee would be eligible for unemployment. The Ohio's unemployment laws have been changed, and one of the qualifying conditions to obtain unemployment under Ohio law now is to be ordered, which I think directed by your employer to stay home for reasons related to COVID-19 would qualify you for unemployment. So if employer and employee are both willing, some type of a layoff there may keep the income stream going for that employee, but not under the paid sick leave law.
Okay, somebody was asking a question just for clarification. They said, did I hear you say that if somebody was laid off before April 1st, they would still be eligible for paid time off if they were employed for 30 days before the layoff?
No, No, if I said that, I didn't intend to. None of the rights for under these laws, under the new law, it impacts any employment action that was taken prior to April 1st. The only thing would be if an employee was laid off prior to April 1st and say comes back to work on April 15th, they'd be entitled as of April 15th to paid sick leave, the 2 weeks paid sick leave. And they'd also be immediately entitled to the paid extended Family Medical Leave Act as long as they were employed for 30 or of the prior 60 days prior to the date of their layoff. So I guess the advantage they would have is if you hire 2 new people on April 15th of this year, one of them you had laid off previously and one of them you had not, the brand new person would not be entitled to the paid family leave for 30 days after April 15th. The person you reinstated could be entitled to it right away if they had 30 days work with you previously.
Yeah, just a thought on, as we navigate, through this, and you had referenced many times as far as the documentation, which could be, it could be, there's a lot there. How do you see the auditing? I mean, like, who's going to audit this as we go forward? Because a lot of businesses are probably unsure of what they're doing and might be nervous about this. Can you lend any advice or guidance there?
It could be the IRS or it could be the Department of Labor that does the auditing. My guess is that they'll have a little bit of flexibility but I can't guarantee it. And I think that it is complicated, but a checklist can be developed fairly easily as to what is needed. And I would just suggest that people do that and not be kind of overwhelmed by it. I do laugh when I saw that the regulations said that the average HR person should be able to figure this all out in 1 hour. They have to estimate compliance costs and so forth. That's not going to be true. I mean, it is complicated. But if you get some good written materials that provide a checklist, here's what's needed and here's what you have to have, and you engage in good faith efforts to be there, there may be some leeway there. You can't guarantee it. The biggest concern I would have is if you are seeking money back from the government, whether to not pay your entire payroll tax or seek a refund, you better have a pretty good calculation that these are I'm legitimately getting this money back from for paid sick leave or expanded FMLA. And if you're the 1 in 100 or so that happens to get audited, here's my file that shows that these are the 5 or 6 things I needed to get, and here they are. If they're not perfect, probably okay. But if there's nothing there at all, it could be a problem.
Bob, and this is situational, so maybe it's just a recommendation, or maybe your clients are dealing with this and you could give some expertise on it. There's a question here that I'm less than 25 employees, considered an essential business. Any recommendations on when my employees take paid leave and we don't have enough employees essentially to operate? Are there businesses locally that are dealing with that, and how are they dealing with that?
It's a really, really tough situation. I think that my advice would be look closely at what those exemptions are. You simply can't deny the paid leave unless it's for that one purpose, which is the taking care of the kids. And even if you deny it on that basis, you better make a finding of one of those 3 things that you're more or less going to be cast out of business if you have to pay this person, which I personally think is a hard argument to make, given that you can recover the money fairly quickly from the IRS from offsetting your tax withholdings. So no doubt it places the business in a difficult situation. But I would not advise any business to deny paid leave or the expanded family medical leave for any of the reasons that it's clearly has to be paid for. The only time I'd even think about it is when there's a child care situation. And you know, we can talk deeper offline on a particular situation, but the law is pretty clear on that. And the government in its paternalistic way is saying, you guys got to cover this and we'll make you whole virtually right away. But this is a pandemic and we need to make sure these people are out of the workplace or are able to take care of people, and you need to do it. So it's not easy advice, but that's what I'd say.
So it seems like the regulations and the policies are changing rapidly. I think I remember you referencing as you were putting together your presentation, changes kept coming over the wire. So you were kind of doing this in real time. But, you know, with some of these, like, if you utilize some of the incentives out there and you do lay off an employee, do you have to bring them back at any point? Will that affect the incentives that you just utilized?
Very well could, Tom. It's a good question. And it's kind of beyond the scope of this presentation to talk in detail about those other incentives, but I will talk about a little bit about the one that people seem to be wanting to utilize the most, which is the Paycheck Protection Program. And that is a very good program where people can receive a significant loan from the government that is forgivable, but it is not forgivable if your payroll is down significantly. But what I will say is this: there is a forgiveness, call it almost a forgiveness abatement period. If you have all your employees back by June 30th of this year, you are likely to be able to enjoy all the forgiveness that the program calls for, which could be 100% of the payroll protection loan. Nobody should run out and sign up for a loan right now, though, based upon that statement, because it's very much on a case-by-case basis how this would work for you. And the biggest key is once you get the loan, and most people are saying if you applied today, today's the first day you can do it. Good luck getting through and applying today. But if you did apply today, it's likely to take roughly 3 weeks for that loan to get funded. But once that money is in your pocket, you have to spend it on approved items in those next 8 weeks. The clock starts ticking right away. And the approved items are basically payroll, is the biggest one, rent, utilities, interest on certain obligations. But if you get the loan now and you don't have that big a payroll because you've laid a bunch of people off, you may not get the entire amount of the loan forgiven. Very complicated formulaically, but there needs to be thinking about 3 or 4 different things at once when you're deciding the strategy for obtaining a loan like that. One of them is, when am I going to be back up to full force? How much of that can I spend in the first 8 weeks after I get the loan? But I will say this: if employers need to do short-term layoffs within these parameters we're discussing, that's not necessarily going to preclude them from having the loan forgiven in full or close to in full in the long run. That's a whole nother seminar.
Exactly. And as I mentioned, there's probably going to be other programs that are out. Somebody had asked, is there another exemption for employers with 25 employees or fewer? Because I know you addressed the 50 employer, but is there anything coming out right now that's actually even 25 or fewer, or do you foresee any coming out?
No, I think this one's is getting pretty locked in where it is, to tell you the truth. The small business exemption is for 50 or fewer. The reinstatement provision is a little softer for employers with 25 or fewer. But all those employers can apply for this paycheck protection loan or for other small business loans as well. And we really encourage people to look into those opportunities.
Okay, awesome. Well, Bob, we're at the end of the hour. It's 11 o'clock, and I can't thank you enough. You've been a great friend to the Wayne Economic Development Council, and you've been a great partner and friend to the Worcester and Orville Chambers. And you always seem to step up when needed. And you're once again a great community friend to just about every nonprofit in Wayne County. So it's a pleasure having you on today. And I can't thank you enough for your service to us at this time, but your service to the community. So,
well, thanks, Tom. Much appreciated. Thanks to all of you.
mm-hmm. So we will forward your presentation to our attendees today. And if there are any other questions, please feel free to send those in. And if you don't mind,